Do you think that there are any unconstitutional applications of your law?
I mean, that's a hard question. I suspect that there might be.
What would they look like?
So the one that comes to mind would be, imagine, and this comes up in their brief, they pick like the most vile example, and they say, imagine a publisher didn't want to publish the book written by the Proud Boys, was the example that they use. I think you might very well have an as-applied challenge to that. But the problem for them is they pick the most vile example when I think all of it would say, well, wait a minute, surely you can let them on Facebook and you can't kick them off because their grandma said something outrageous, right? So there's got to be a limit there, and that's why a facial resolution of this case doesn't work. And if it is,
and how do you separate the one from the other? Where's the line?
That's hard, right? I would say this court struggled with that in 303 Creative because it's really hard to know when something becomes inherently expressive. And the court's cases like Dale about when is something that happened, all of those are hard cases. But in all of them, this court has had facts. They've actually looked at the facts of the case and tried to figure out, as applied, whether that makes sense here. In this situation, there's a million applications of this law that are perfectly fine. And they pick some of the most vile possible hypotheticals, ignoring, by the way, the provision of Texas law, which they never address, which says under Texas law, if you don't want to hear content, they're allowed to make sure you never hear that content. So all you have left, I mean, again, they never mention at all, that's like the focus point of our brief, they never respond to it. But that means all that's left is, I don't want to hear this type of speech. I just want to hear this type of speech, and it's just voluntary communication. That's a telephone.